brother down with Shizzy, Wiz, Nut.
Good afternoon. I'm hoping to do a nice little short run here, and it's going to be a short video. I hope that you enjoy this and stay tuned because we're going to have a letter for Bubbles. Oh, the judge. Referral in order. Judge Magistrate came in here, Judge Bolitho, and he said, ordered upon consideration of the foregoing, it is ordered this 31st day of March 2025. Defendant David Helm has filed a motion seeking a 7-day extension to respond to plaintiff's complaint. Document 10. The motion states the plaintiff counsel has no opposition, and that if you read this really closely, the motion states that plaintiff's counsel has no opposition. 1. According to defendant, Helm's motion, Doc 10, is granted to the extent that his response to plaintiff's complaint is due on or before April 7th, 2025. So that's just going to be 7 days away that his response to the plaintiff's complaint is due. It is apparent from the motion that defendant Helm's counsel conferred with plaintiff, and pay close attention to it here. Apparent from the motion, defendant Helm's counsel conferred with plaintiff's counsel before filing the motion. Doc 10 at paragraph 2. See this right here where it tells him in 7.1b, in future motions, however, counsel must include a certificate of conferral upon a separate heading. And there's a possibility that this attorney didn't quite know all the rules. He definitely did confer with him. He just never filed the conference. Now, is compared to this next one where the judge, same judge, almost within minutes orders this upon consideration of the foregoing. It is ordered this 31st day of March 2025. Defendant Brucey has moved for a 30-day extension to respond to plaintiff's complaint. Pro se parties, and notice where he says pro se parties who are not in custody must confer with opposing counsel before filing a motion. Because defendant Matzkin's motion fails to provide any indication that he conferred with plaintiff's counsel and also fails to include the required certificate of conferral under Florida rules, the motion, Doc 11, denied without prejudice, which means he can file it again, which I'm sure that he will. But the judge wants him to confer with counsel. Oh my. But once I saw this, I was like, oh boy, this is going to get wild. The judge is definitely not playing in this situation whatsoever. He's telling him, nope, try again. So we're going to, read you guys a nice little letter. As you notice, we've got the helmet. Oh yeah, because I can't, my camera is not working. So we're going to get this motion, this nice little letter to Bubbles. We've got to get the music happening just for you guys. So let's get to it. What do you say? Make sure that you like and subscribe to this. And hopefully we'll see a little bit better motions being made in this particular case with Zip Bubbles, because it's going to get crazy. Oh, you have no idea how crazy it's going to get. But let's get the music and the letter. I hope you guys are ready for it. Here we go. Oh, well, that's loud. All right, let's bring that down to a decent level. All right, here we go. An open letter to Bubbles, aka BBB. Your extension request got yeeted by a judge because, well, of course it did. Dear Bubbles, well, that didn't take long. You waddled into federal court asked for an extra 30 days to find a lawyer. And what did you forget to do? Literally, the one thing every competent law school dropout, courthouse janitor, or caffeinated YouTube commentator knows to do. You forgot to confer. My God, man, you've been on this case for almost a year, practicing law for over 27 years and still cannot file a motion correctly? You've been too busy chasing ambulances to read the rules? Well, let's be clear. The judge wasn't asking for blood, a handwritten apology, or even a decent motion. He was asking for a single, basic, kindergarten level procedural requirement. Something so simple even I could do it while licking a window and wearing my Velcro shoes. But you couldn't. You didn't. You filed a motion that said, "Oh, please give me more time because I have no friends," and forgot to check the box that says, "I talk to the other side like a big boy." You're not confused, elderly bystander who wandered into a courthouse thinking it was Walgreens. You're a licensed attorney who's been sanctioned more times than a third world dictator and who files more crap in a federal court than LexisNexis on meth. Now, I'm officially on the record. It is officially on the record. Your motion was denied. No substance, not for timing, not even because you're a human embodiment of a Rule 11 violation. No, it was denied because you didn't follow the most basic rule in the district, the conferral rule. You've been barking legal threats at everyone with a Wi-Fi signal for a year straight. You've been sliding into Preston's inbox with legal coaching, spanking your monkey to Lisa Weeks' courtroom LARP sessions, bribing minors for audio files like a rejected Dateline segment. You spent the last year declaring yourself the brains behind the anti-what-the-hell's media ecosystem. But at this point, it's clear you're not the brains. You're the tumor. You forgot to tell the court whether you even tried to talk to Hill's attorney. Well, no email, no call, no smoke signal. And because you didn't attach a certificate of conferral, you now have a court order with your name on it. That's the judicial equivalent of a teacher sending your crayon drawing back with a big fat nope scrawled across it in red pen. This isn't your first faceplant. It might be your dumbest yet. You, a sanctioned attorney who's filed more angry PDFs than a TikTok lawyer during an election season, just got dunked on by a deputy clerk and a judge in one motion. It's honestly poetic. You spent months pretending to be the dark wizard behind the ANTI-WTH's curtain, slinging accusations, fueling conspiracies, grifting for money, writing half of Preston's Facebook fanfic legal defense and trying to pass off your insanity as strategy. And now you can't even get a 30-day extension approved because you forgot to play nice. Well, you're not being railroad, Bruce. You're just terrible at your job. The judge even left the door open with a denied without prejudice, which is court speak for try again, genius, but do it right this time. Don't worry, though. We know what's next. You'll refile it, probably wrong again, maybe this time on a napkin, or maybe handwritten this time, or dictated to Lisa Weeks while she hosts a live stream with 7 sock accounts cheering you on, or with just another fake name, or maybe you'll CC your latest sock puppet, Stephen Hoke, for moral support, and you'll forget something else, because at this point, the only consistent legal strategy you have is screwing it up in new and exciting ways. You are the legal equivalent of a fart during a eulogy, loud, disruptive, and leaving everyone in a room just a little bit dumber for having heard it. So from one mentally unstable internet commenter to another, thanks for the content. You're the gift that keeps on losing. Warmest regards and zero professionalism. Shizzy Wiznut. Helmet secured, short bus warmed up, and still more procedurally competent than you. And that right there, ladies and gentlemen, is the latest letter. I hope you make sure that you hit that like, make sure you subscribe if you haven't done so by now, and stay tuned. Strap on, buckle up. It is about to get wilder and wilder. There are more filings due to be coming out, and in just a few days, just a few short days, Bubbles is going to be in court, sitting in front of this judge. How do you think the judge is going to react to all of this? Put your comments in the section and see what comes of it. Everybody, have a wonderful day and see you very soon. Peace.
It is about time. Let's break this mother down. With Shizzy, Wiz, Nut.